everyone, welcome back to my channel where we simplify complex legal topics into simple topics for you. Today we are going to talk about an act that plays a crucial role in Indian judicial system, the Probation of Offenders Act 1958. Imagine if a minor offender could get a chance to reform without having to face the harsh realities of prison. Sounds interesting, right? Stay tuned as we break down this act and explore how it aims to reform rather than punish. In this video, we'll cover the introduction to the Probation of Offenders Act 1958, the rationale behind its enactment, 2. Key provisions of the act focusing on sections 3, 4 and 12, 3. Recent updates, any new amendments or important changes, 4. Case laws, key judgments that have shaped the application of the Act. 5. Commentaries by judges, insights from the Judiciary and on the Act. 6. Conclusion and recap, summarizing the main points and the Act's impact. The Probation of Offenders Act 1958 was enacted to promote the reformation and rehabilitation of offenders. Instead of sending minor offenders to prison, which can often lead to more harm than good, this act provides an alternative by placing them on probation. The aim is to integrate these individuals back into society under supervision, encouraging them to lead law-abiding lives. Section 3 allows courts to release an offender on probation instead of sentencing them to imprisonment for offences that are not punishable with death or life imprisonment. The offender must enter into a bond with or without sureties, committing to good behavior for a specified period. Under Section 4, courts can release an offender after due admonition if the offence is punishable with imprisonment of 2 years or less, or with fine or both. This provision focuses on minor offenders, giving them a chance to reform without facing the severe consequences of imprisonment. Section 12 states that a person convicted and dealt with under Section 3 and 4 will not suffer any disqualification attached to a conviction under any other law. This provision ensures that the offender's conviction does not affect their personal or professional life, aiding their integration into society. As of the latest updates, there have been discussions of making the probation system more robust and comprehensive. Their aim is to enhance the support mechanisms for probationers, including counseling and vocational training, to ensure they do not re-offend. However, no significant amendments have been made to the Act recently. Stay tuned to our channel for any further updates on this topic. Let's look at some landmark judgments that have influenced the interpretation and application of the Probation of Offenders Act. State of Gujarat versus B. A. Chauhan. In this case, the Supreme Court emphasized that the Probation of Offenders Act should be interpreted liberally to promote its reformative purpose. The court highlighted that probation helps in the reinforcement of offenders and the reintegration into society. Second is Ramji Mishra versus State of Bihar. The Supreme Court noted that the Act aims to prevent young offenders from being exposed to the detrimental effects of prison life. The court stressed that the Act should be applied to first-time offenders and those guilty of minor offences to advance its reformative objectives. Third case law is Mohammad Azizul Haq versus the State of West Bengal. It's a 1974 case. In this case, the Calcutta High Court reiterated that the primary purpose of the Probation of Offenders Act is to reform offenders rather than punish them. The court understood that probation is a corrective measure designed to help offenders mend their ways and become responsible citizens. Justice V.R. Krishna Iyer has often spoken about the importance of the Probation of Offenders Act. He emphasized that the Act represents a shift from retributive justice to restorative justice, focusing on healing and rehabilitation rather than punishment. Justice P. N. Bhagwati highlighted the humanitarian aspect of the Probation of Offenders Act. He believed that the Act plays a crucial role in reducing recidivism and helping offenders lead a law-abiding life post-conviction. In conclusion, the Probation of Offenders Act 1958 is a significant piece of legislation that promotes the reformation and rehabilitation of offenders. By providing alternatives to imprisonment, the Act helps reduce the negative impact on incarceration on offenders, especially those guilty of minor offences. So let's recap what we have learned. The objective: the Act aims to reform and rehabilitate offenders instead of punishing them with imprisonment. Second, we learned about the key provisions. Sections 3, 4 and 12 are central to the Act, focusing on probation and removal of disqualification attached to conviction. Third is the recent updates that we have discussed. Discussion about enhancing the probation system, but no significant amendments recently. 4 is case laws that we have discussed. Landmark judgments like State of Gujarat versus V. Chauhan, Ramji Misra versus State of Bihar have shaped the interpretation of the Act. 5 is judicial insights. Judges like Justice Krishna Iyer and Justice P.N. Bhagwati have highlighted the importance of the Act in promoting restorative justice. Thank you for watching. If you found this video helpful, please like, share and subscribe to our channel for more insightful legal content. Let us know in the comments below what other legal topics you would like us to cover. Until the next time, stay informed and stay legal. Bye-bye.
Living life, every day, late at night, not okay. All I want, and I pray, all I need are some better days. Fuck me, I'm looking in the mirror, so foggy, but I've never seen clearer. I don't really think anyone can save me, and honestly I'm not really sure I want saving. I like to be my own worst enemy. There's no risk if you don't try at anything, so I'ma just keep buying everything. See you in the next life, have to be a better me. I don't think that my head's on straight.